There are several obstacles, and I'm just going to pinpoint a few. Information requested has not always been collected, so it's not there. I mean, you may try to obtain it, but the fact that it was never collected in the first place, and it was never processed in the first place. So no matter whatever request you make, it's just not there. So this is the first problem. Then there's the problem of assessing, well, the access can actually be granted, but there's the problem of, is it granted in a timely manner? You need the information today, and facts need to be contextual. I mean, they are contextual, so you need them today in order to act today. You can't act on information which is 5 years old. Now imagine what's the value of that information for civil society. It's zero. Then there's the problem of the technical nature of the contents of these legal administrative documents. Most of these materials are not intelligible to the common citizen. They are produced in such a technical and heavily juridical language that the common citizen won't really, even if you ask for the information, will understand a thing of what's going on. On data collection, mostly we do desk research, statistical research, and we use key informants for interviews. Desk research consists of a lot of things, but you should always check for other reports on judicial performance in your country. That might be useful to give some context to how the convention is being implemented. If there's no data, you have to ask why this data is not there. And if there is, you obviously want to know whether it's reliable, and you want to check for the results. And you can also do some field tests. Sometimes you only get a good understanding of how these mechanisms work if you actually test it. I mean, I've dealt with a lot of legislation concerning assets disclosure, but the best experience I got was actually to test the assets disclosure mechanism in my own country. Just a quick note on the interviews. Don't forget, interviews are a good source, but often they're a good source to fill in holes. Don't forget you're interviewing key players. So you always have to balance for the information they give you. You're not telling stories, but you're analyzing facts. I mean, stories in the sense, of course, you have to build cases which justify and give you examples of how the system of enforcement works. That's fine if you deal with specific court cases to demonstrate that. But you know, when I say storytelling is on top of your head because you've read somewhere in a newspaper and you carry on divagating about that. I mean, make sure that you're dealing with facts and you want your report to be as credible as possible. Check your sources, make it reliable. There's nothing worse than presenting a report of this kind to a decision maker and the information is not reliable. The objective of your research is to transform information into knowledge which can be used by others. This is a very complex topic, very legal based, and it's not easy to transform that information into something intelligible for other people. So it requires a combination of expertise in law as well as expertise in advocacy and communication strategies. Try to use concise and clear language and go straight to the point. And my recommendation always give to my students more substantives than adjectives or adverbs. Okay? Substance, that's what we want in a report. And believe me, if you're giving to a decision maker, and if by page 5 you haven't made your argument, forget it. You won't read it. A decision maker, an MP, whatever. So you have to make the point right at the beginning. Executive summaries, as you said, it's a perfect tool. You spot you place there your findings, your major findings, the major obstacles in the implementation of the convention, and your set of recommendations. And if you can get this in a page, it's perfect.
The question is what kind of information gathering strategies CSOs should have. And there are essentially two sources of information. One is official information from the governments, which you would get by filing a request for information, especially if your country has an access to information law. And then the other source is other organizations or academics, NGOs, who are collecting information, think tanks and so forth, who may have some information which is useful. You can't file an official request for information with these organizations, but you can talk to them and ask them what information they've been able to collect. Also, it's useful to bear in mind that academics often get access to government statistical data as part of their work through their contacts in government, which you as civil society may not have been provided. So it's worth talking to academics to know what information exists and what information they've had access to, both in order to be able to get some information from them and also to define more clearly the information request that you're filing to the government. If your organisation is planning to file requests with government and you're not absolutely sure which body you should file the request with, it's better to file a number of requests at the same time than just file one request and wait to be referred to another institution. You're going to save yourself time like that. So if you're not sure, or if you think more than one institution holds parts of the answers, send all those requests off and see what information you get back. Follow up quickly if you're referred somewhere else, and that way you'll save time in getting the information that you need to write your reports.